Buhari behind DSS refusal to release Nnamdi Kanu despite court order. The rule of law and the constitutionalism have finally been nailed to coffin in Nigeria by President Muhammadu Buhari. Throughout the history of democracy, rule of law and constitutionalism in the country, be they parliamentary or presidential, Nigeria had never been experienced the kind of insult, mockery and bastardization it presently experiences under barely 7-month-old presidency of retired General Muhammadu Buhari. Human rights records of the present administration are also negatively alarming, shocking and deafening. All the third generations of human rights, civil or political, economic, social, cultural, environmental and development community rights are observed in gross breach by the Buhari administration. Nigerian judiciary under his administration is no longer the bastion of democracy and last hope of the common man. It is now a leprous arm of government, being mocked and cajoled from left, right and center. A civilian government that makes mockery of and disobeys the rule of law and constitutionalism is worse than a man running amok with a sharp dagger in a crowded marketplace. Citizen Nnamdi Kanu is today made a prisoner of conscience by President Muhammadu Buhari and his DSS. The President and his DSS had in the past 60 days flouted and gravely disobeyed 4 express and consensual orders of the Wheels Zone 2 Magistrate Court and the Federal High Court, Abuja Division, bordering on Citizen Nnamdi Kanu's constitutional right and personal liberty, association, assembly, dignity of human rights, human person, life and expression. It is freshly recalled that on 19 October 2015, His Worship Honorable Shaibu Usman of the Whole Zone 2 Magistrate Court in Abuja granted conditional bail to Citizen Nnamdi Kanu, and on 22nd October 2015, all the bail conditions were fulfilled. But the DSS refused to release him on bail, claiming it was acting based on the personal directive of President Muhammadu Buhari. The magistrate court order for his bail was followed by 2 other consequential orders which were also flagrantly disobeyed by the same DSS. On 18th November 2015, the DSS told the Whole Zone 2 Magistrate Court that it had on 10th November 2015 secured an expert order from the Federal High Court, Abuja Division, to detain Citizen Nnamdi Kanu for 90 days for the purpose of investigating him for terrorism and terrorism financing using the flooded defense of unconstitutional section 27 (1) of the Terror Act of 2011 as amended. On 17 December 2015, the same Federal High Court, presided over Honorable Justice Adeniyi Ademola, struck out and dismissed the DSS fraudulently and unconstitutionally obtained 90 days detention order and ordered for immediate and unconditional release of Citizen Nnamdi Kanu. The DSS release again flouted the order and introduced delay tactics attached with stringent conditions to frustrate the signing of final discharge papers at the Federal High Court that would have allowed Citizen Kanu to go home same day. We were shocked to observe that 24 hours after the DSS brazen resort to delay tactics and stringent conditions, contrary to the order of the Federal High Court, it came up again yesterday, 18/12/2015, with further delay tactics, claiming that its DG must be present and personally sign Citizen Kanu administrative release order. As these delay tactics were going on, the presidency reportedly called and defiantly directed that Citizen Kanu must sign an undertaking renouncing his pro-Biafran agitation as a condition for its compliance with the court order failure of which he should remain detained in the DSS custody and be slammed with fresh, false accusations. Treasonable felony. It was on account of the insistence of citizen Kanu's lawyer that the order of the Federal High Court must be obeyed and enforced to the letter that the DSS refused to release citizen Kanu, claiming that he was being held on suspicion of commission of treasonable felony. Citizen Kanu's lawyer and families, members, and friends spent over 18 hours yesterday from 10 a.m. to after midnight waiting for DSS to release him to them as ordered by the Federal High Court, all to no avail. Just like the phantom and failed accusation of terrorism and terrorism financing, the second phantom accusation of the treasonable felony is also dead on arrival. We had in one day of our recent public statement boldly compared the difference between a democratic statesman and a civilian dictator or despot. While the former binds and heals national wounds, the latter creates and inflicts national wounds. While the former is an upholder and respecter of the rule of law, human rights and constitutionalism, the latter is a manipulator of the rule of law and constitutionalism. He also exploits that the weakest provisions of the laws includes retrogressive, retroactive criminal legislation and ouster clauses for the purpose of entrenching his dictatorial or despotic grip and engaging in gross infringement of the citizens' fundamental human rights. All the attributes of the latter above mentioned bear true characteristics of President Muhammadu Buhari and the civilian administration. For the avoidance of doubt, the offence of treasonable felony is defined by Section 41 of Criminal Code as follows: any person who forms an intention to effect any of the following purposes, that is so to say, to remove during his term of office otherwise than be constitutional means the President as head of state of the Federation and Commander-in-Chief of the Armed Forces thereof, or to likewise remove during these terms of office the governor of a state, or to levy war against Nigeria in order to put any force or compel the President to charge his measures or conceals, or in order to put any force or constraint upon, or in order to intimidate or overpower any house of the National Assembly, or any other legislative or legislation authority, or to instigate any foreigner to make any armed invasion of Nigeria or any of the terrorists. Therefore, manifestation of such intention is an act is guilty of a felony and is liable under to imprisonment for life under Section 43 of the same Criminal Code. A person cannot be tried for treasonable felony or concealment for treason unless the prosecution is commenced within 2 years after the offence is committed. Provided below is the detention time limit under Part of 30 of the Administration of the Criminal Justice Act of 2015, ACG Act 2015, relating to stipulated periods upon which a citizen accused of committing any offence in Nigeria can be held in pre-trial detention through court remand pursuant to application for the issuance of order ex parte at the Magistrate Court by Section 293(1) of the Act. A suspect arrested for an offence which a magistrate has no jurisdiction to try shall, within a reasonable time of arrest, be brought before the Magistrate Court for a remand. An application for remand under section shall be ex parte and shall A be made in the prescribed report and request for remand form as contained in Form 8 in the first schedule to this Act, and B be verified on oath and contain reasons for the remand request by Section 295. The court may, in considering an application for remand brought under Section 293 of this Act, grant bail to the suspect brought before it, taking into consideration the provisions of Section 158 to 188 of this Act relating to bail. Let me know what you think in the comment section about this news. Also, don't forget to like, subscribe, and turn on post notifications, and we'll see you on the next news.